Good evening and welcome to the Hudson Zoning Board of Adjustment meeting of May 24th, 2000.
No, we are.
Pardon?
We weren't on when you said that,
Oh.
so
24th, 2018. This meeting is called to order at 7 o'clock. We're meeting tonight to hear requests for relief from the Hudson Zoning Ordinance. And the following are the rules of the program tonight. It's a quasi-judicial board where we don't make new policy, but really we're hearing and referring to and enforcing the state zoning laws as well as case law of each of the different parts of the zoning. At this hearing, we'll be soliciting input, hearing rebuttals, and then the case is deliberated before the board. Generally, there's 2 rounds of testimony, chance for the applicant to respond to possibly any negative questions or comments from people in the audience. There's handouts in the back of the room that will highlight the agenda for tonight's meeting. This will also contain the process for appeals, should anyone feel aggrieved or in disagreement with what decisions are made tonight. Each of the applicants will be asked to come to the lectern, give their name and address, and please spell your name out so that the recorder can get it accurately. Before we begin, there's just a couple of housekeeping items. Please, everybody turn their cell phones off. It's quite distracting if something, get a call or whatnot. The speakers we have in the room are quite sensitive, and when they pick up cell phone ringing and talking, please refrain from talking. It's very hard for people to hear what was said in the recordings and to take minutes of the meetings. There's no smoking in the building. If you need to, please go outside and have the cigarette or whatever you need. With that, will the call the roll?
Yes, sir. Ms. Davis?
present.
Mr. Dearborn? Present. Mr. Pecosha is excused.
Excuse.
Okay. Mr. Petrie?
Present.
Mr. Hool is present. Mr. Moran? Mr. Martin?
Present.
Mr. Buttrick?
Present.
Ms. Nee?
Present.
And Chairman Brackett?
Present. Given that we have 4 members, 1 member absent, I'll sit both Kevin Hool and Mike Petrie to fill the board. Will the zoning administrator read the first case into the record?
Case 165-75, May 24th, 2018. Michael Baltacino, 7 Merrimack Street, Hudson, New Hampshire. Requests a variance to rebuild the existing front stairs with an increased setback 13.8 feet from the front yard setback, where 30 feet is required. It's map 165, lot 75, zone TR, the Hudson Zoning Ordinance Article 7, Section 334-27, Table of Dimensional Requirements.
Who here to speak? Okay.
Good evening.
If you give your name, spell, and your address.
Michael Baldacchino, Michael, Baldacchino, 7 Merrimack Street.
If you present your case.
So this is in request for ordinance Article 7, Section 334-27, the table of dimensions. The request for relief for the setback from the street. Item 1, granting of the request variance will not be contrary to the public interest because of, and, you know, my response to that was, there are multiple homes in the neighborhood that are much closer dwellings themselves than the stairs would be at 7 Merrimack Street. Also, the existing stairs measure 23 feet from the road to the bottom step, which does not comply currently. Item 2, the proposed use will observe the spirit and ordinance because, well, to meet the rise and run codes of the building codes, I would need to add an additional 3'6" to the existing layout, which is still 23'6" to the street, which still does not comply with the 30-foot setback. Item 3, substantial justice would be done to the property owner by granting the variance because the existing stairs are a safety danger to anyone using them, which could cause subject the owner to injury or lawsuit, being me. Item 4, the proposed use will not diminish the value of the surrounding neighborhoods because this will be an updated, structurally sound, and up-to-code set of stairs. Item 5, the conditions exist such that the literal enforcement of the ordinance will result in unnecessary hardship because the current stairs are a safety hazard, as the rise and runs are a trip hazard. Also, the stairs are a safety hazard due to the structural unsoundness of them. Not being able to replace the front stairs will force the owner, me, and his family to use the back entrance of the house. Also, in the case of an emergency, the front current stairs would also increase danger, further danger or injury, and it would only give me one entrance to my house versus having two. So I also have some pictures too.
Sure.
Of the. Yep. Let's have 2 sets. They're marked on the back, whether it's the 7 Merrimack Street, the home in question, or the neighborhood, or the existing conditions.
That conclude your testimony?
Mm-hmm.
Okay. Is there anybody else would like to speak in favor of the applicant and the variance? Seeing no one, is there anybody who would like to speak neutrally or in opposition to the variance? Again, seeing no one, I'll declare it for discussion from the board. Questions from members of the board?
I drove by the location on 2 different occasions, and these stairs are in very tough shape. It's almost putting your life at risk walking up and down them. I have some real grave concerns that these things are gonna collapse in a very near future, so. I personally think that if a variance is ever granted or allowed, it should be in this particular case where there's, health is at jeopardy because of the conditions.
Anybody else?
Thank you.
2 questions, one for the applicant, one for Bruce. The beginning part, Bruce, I apologize, but did the applicant come just to put an application in for improvement, and that's how it got flagged for the setback, or?
I think he was aware that if he was to rebuild and rebuild larger, that he'd need to get a variance. So we did a zoning determination saying, yes, that's true, because of the stair geometry, rebuilding them to code would further encroach, and he knew he had to come in and get the variance for a setback.
With riser and tread height, you mean?
Right, for the riser tread geometry, exactly, yeah.
So in the proposed, in the drawing, is it an L shape of the deck and going down to the right, or is there stairs on both ends of that deck, on the platform? Because the drawing.
Yeah, it looked like it was on both sides, but it's hard to tell.
Yeah, just, so it comes straight down to the landing, and then, V's off.
To the right.
Yeah, yeah, right,
The way it's drawn, looks like it goes both ways.
right.
That's all I had.
So if I may, the entrance will be from the driveway side portion as opposed to the front on?
It would be
Based
both.
on-
It's a open, it would come down, and the handrail would be on the left and the right, but the stairs would go like this.
So it is like an L shape.
Yeah,
Oh, it's
yeah,
gonna be
I'm
L-shaped,
sorry.
okay.
I misunderstood the
I was
question.
asking.
Okay. Any other discussion?
I'm prepared to make a motion if
Your motion?
this is pretty quick, but, I mean, the existing stairs predate the TR zone for that area. The intrusion into the setback is a non-conforming use, and in order to meet the current code, the applicant needs to have more intrusion. I mean, he's just really complying with the riser and run codes allowed. So I'm making a motion to grant.
Grant, okay.
Sorry.
Second. Any discussion, further discussion on the motion? On your, go ahead.
It's always good when applicants come in and apply for stuff rather than just building and ask for forgiveness later. Even on the small stuff.
But if you look at the character of the neighborhood too, it's all the TR zone is, that these homes have been there prior to that. And all the other homes within the neighborhood
We're a lot closer.
are in
now.
the setback, yeah. Well, I mean, the front steps are in the setback.
We're all the same, I saw
Yeah,
that.
Homes are.
same. Yeah,
The homes itself, yeah.
yeah.
Speak on your second?
I think it's a safety hazard, we're correcting a safety hazard, to be honest with you, by allowing this variance to go through.
I would agree. I don't see any other alternative but to allow this corrosion into the setback, given this, where the house is built, and there's a lot of other homes that are worse than this too, so. Full the board?
Yes, sir. Ms. Davis,
To grant.
Mr. Dearborn,
Grant.
Mr. Hool is to grant, Mr. Petrie,
Grant.
and Chairman Brackett.
To grant, seeing the vote is 5-0, the variance is approved.
Thank you, everyone.
Mr. Chairman,
Yes.
point of order, a 30-day,
Oh, there's an appeal period of 30 days, so if you were to do any action now, it's at your own risk. So it's up to you whether you wait or take the risk in building it now, just for your information. A few minutes just to fill out the forms.
Yes.
Leave the next case into the record.
Case 200-3, May 24th, 2018. Ryan Reed, 11 Rumford Street, Lowell, Mass. Requests an appeal from an administrative decision by the zoning administrator dated April 11th, 2018, for the property located at 89 Pelham Road, Hudson, New Hampshire, which states that the proposed connector roof structure between both buildings to satisfy the definition of a two-family duplex will present a reasonable appearance and will be in keeping with the neighborhood character. To map 200, lot 75, zoned G, Hudson zoning ordinance Article 2, section 334-6, definitions, and the Hudson zoning ordinance Article 3, section 334-16.C.1, building permits, conditions of issuance.
Background on this case and why is it here?
As you know, it's an appeal of a zoning determination I did. It comes down, I think, to the semantics of the definition of duplex, two dwelling units attached by any portion of one or more floors, walls, or roofs. But I don't believe that that definition in the proposed construction as presented satisfies the intent of the Hudson zoning ordinance 334-16.c.1. The conditions of issuance, which states no permit, however, shall be issued unless the structure will present a reasonable appearance and will be in keeping with the neighborhood, and unless the building is to be finished on the exterior in a permanent manner and is to be suitably painted on the outside whenever the same is of wood or a material customly painted. This is intended to eliminate the erection of structures obviously out of place for the neighborhood, as judged by the property values and neighborhood character. And my assertion is that I believe the proposed construction will be out of character as a duplex. In a simplistic situation, a duplex is basically side by side with some sort of a connector or a garage in between. This one is offset, and I think you'll see that in one of the sketches.
And would you introduce yourself, spell your name?
My name is Ryan Reed, Ryan Reid. I'd like to say thank you all for giving us the opportunity to come tonight. I'm the owner of Mill City Remodeling. I am doing the work for the Dolettes. We're looking to change the existing garage into a house, a duplex for their daughter, because the father's just got ill within the last couple of months, so we're trying to get her into there. But as you know, duplexes are typically side by side, up and down, but my client's situation, that's not the case. They're looking to change the two-car garage dwelling by using the right side of the entrance. You'll walk into the first floor. That'll be the first floor kitchen area, and then there'll be a second floor. There'll be a bathroom and a bedroom. So by definition, a duplex is a dwelling having apartments with separate entrances for both units which share common wall, ceiling, or roof structure. Another name for a duplex is called a semi-detached or a twin home. A semi is a single-family dwelling that is built in pairs on the same land as they share a common wall, ceiling, roof, or roof structure. However, there's no real set design plans for any duplex other than the traditional design, which is, commonly a two-door or the shotgun houses that we all know about. They're side by side. But if you Google, there's no real set designs on duplexes. There's many different variances on duplexes and condos and townhouses, how they connect and with roof structures and all. So what we have here, there's the Dutch gambrel, which is, not a traditional in, New England, in the last few years, more colonials and capes. So what we gotta do here is I'm gonna have to add a permanent roof structure that'll connect the two dwellings, the Fair Housing Act, to make these two units into a duplex. It would be a permanent roof structure that'll connect the two down the alleyway that leads to the main house. It's not necessarily the traditional fashion as, side by side or a two-floor duplex. There's many different duplexes out there. We can drive up and down any street, there could be any duplex. At the corner of Pelham Road, there's a house, older house with a garage setback with a little roof attached. For me, that's, does not look good with the character of the neighborhood. But we're not doing anything, we're not constructing a new garage, it's existing in the garage, both of them are gambrels. And we're just doing a a permanent roof structure, connecting the two. That's all I gotta say.
Is that it?
Yep.
Anybody else wish to speak in favor of the application? What?
This is an appeal. Appeal from the zoning.
Oh, right,
We're not really hearing the case.
So we
We're trying
don't
to decide
hear-
whether his decision was,
yeah, okay, sorry. Questions from the board, discussion?
I do. Well, I have a question for Mr. Buttrick. Is this town water and sewer?
I don't believe both are, maybe town water,
No, the well.
it's both.
Well and septic,
Well,
well
septic,
and
yeah.
septic?
Private water and septic.
So, just for discussion purposes, please?
Sure.
How would this play into the new ADU law?
And if they were to do an ADU, it has to become attached to the single family. They had to approach to do the ADU approach, but it'd have to be walls as well, you know, because it has to be connected to the single family. And I think the living area may have been larger than 750 square feet. So it would kick it over the requirements for ADU.
Okay.
But the two-family duplex is an allowed use in that zoning district.
Mhm.
So they approached to say, well, maybe we can satisfy the connector with a roof and satisfy the definition. I think it's really a matter for the board to determine, decide if our definition is clear enough to entertain a connector as being proposed, actually satisfies the intent of
Yeah.
duplex
I mean,
two-family.
that's all we see in town is, because that's what our ordinance requires.
Right, it's the typical standard
Yeah.
duplex.
How about the new, warrant article that you can have two principal uses on a lot without the area and the frontage? Because this could technically be a standalone second house.
I suppose if it didn't have the connector, and they wanted to do two primary residential
Principal
uses,
Yeah,
one, they'd need to have planning board, because that's, kicks in a site plan requirement,
Yeah, it
because
does
it's
too.
more than one single family.
right.
I believe there's not a mixed use, it's a dual use, because it's both, single families, you know, that aren't connected, but
So
I'm
they
not sure.
probably, would they need a variance for a dual, mixed or dual use on a
They
lot?
couldn't satisfy the ratio requirements that are, you know, for each. I think it's okay for the, what is it, for primary, I wrote it down here on the.
If they don't need it now, they don't need area and they don't need frontage now.
As long as it satisfies one of the
One of the
primary
two, yeah.
principles, right.
So as long as it's a
right.
conforming with
Right.
the one.
Yeah.
Yeah,
But it would need planning board
But
site
it need
plan.
planning board.
Yeah.
Mm.
but they're in for they're not in for that, they're in for.
No, I'm just, in order for me to determine whether the zoning administrator made the correct decision or not, I just wanted to get more background.
Okay,
That's
yeah,
all.
but we still,
Because we're not in to make any decisions on this. They're just appealing
His
what
decision.
Mr. Buttrick has said. Yep.
right.
Yep.
Mr. Dearborn?
I asked Mr. Buttrick, on Greeley Street in Hudson, the next house above the Jehovah Witnesses is a case very similar to this, where single residence, the garage was built into a second home and just a roof connecting to both of them. This is basically the same difference, isn't it?
Very similar. I drove by, took a look at that.
Yeah,
It would be very simple, comparable, similar to that.
yeah. So
And-
that,
That was a longer walkway that way versus.
yeah, and that's
horizontal.
nothing but a roof.
Right, yep.
There's nothing inside, or there's not a building connecting it, just a way around the zoning law to
Structure.
allow a second home out of a garage there on that.
There's one on Burns Hill, too. It's a little bit better than a carport, but it's integrated into the structure such that it does look like a split duplex of sorts. I have questions of the applicant. Am I reading this right, the awning, basically what it is 10 by 9.5 feet?
Yes, sir.
Because one of them shows a different dimension.
I could be wrong on one of them, I could have wrote it wrong. I believe the walkway is 10 feet wide where I'll be
Yes.
connecting the roof itself, and 9 feet in height.
And the overlap on that awning from one house, one structure to the other is 2 feet?
Yeah, it's,
I mean, excluding the new porch
yeah, we're
or
doing a
deck.
Deck, yes.
So it's
So-
really a 2-foot overhang.
Right, that's where, both of them, there's a 2 foot difference, yes,
In order to catch the other building.
Yep.
It's 2 feet.
2 feet. And then that's why we're adding the back deck, which would be 8 feet, because that's be attached to,
Yeah, but it's a deck.
it's attached to the main structure.
What's the flooring gonna be? Is there a flooring? Is it dirt?
No, it's concrete floor. We're doing, sandblasting, and we put on sandblasting and doing epoxy on the concrete floor.
It's awful hard to understand your sketch. So if you could explain that a little more, I'd appreciate it.
My printer broke, so I wasn't
wanna
able to
take
print
these
it.
too?
Yes.
Because it shows
I would
roof
like to know
rafters
too,
and
thank you.
shows roof rafters and metal roof.
Metal roof, yes. So
So-
I plan on doing, like a timber type, with the trellis, rafters and with the metal roof on top, with pine tongue groove for the ceiling.
Is there a back to it, or is it just the roof and the concrete?
Is there what?
Is it open front and back?
Yes, it would be open front and back.
So we have a roof structure that overhangs 2 feet, and it's open front and back. And that's the connection that forms the duplex.
Yes.
Okay.
Can I
Go
ask,
ahead.
the existing garage, can I ask directly to the applicant, or do you want me to ask you?
Go ahead.
Okay.
I mean, I'd rather not.
This is kind of informal.
Yeah, well, yeah.
Well, so for the existing garage, is that gonna remain, the other half is going to remain a garage?
Yes, ma'am.
Is the auto body,
No,
Place
that's,
still here?
nope, that's
the
gone.
auto body's gone?
Yes.
Is anyone living over the existing garage now?
No, ma'am.
There's no one up there?
There isn't?
No. Well, the existing garage right now is just a open room.
What is, this is my question, what is this?
Okay. Other questions? Go ahead.
One for Mr. Buttrick. Just following Ms. Davis's conversation and some hypotheticals, and on its face, looking at the open concept and going through, I believe it doesn't conform to the current duplex type situation. If the applicant had come in with a similar type thing where it was closed in, main entryway, and you went left to right, would you have looked at that differently, technically? And that's a hypothetical.
I would have, and as I think we did a couple renditions about, or iterations of first with an ADU, which would require the walls, because it had become part of the structure,
Correct.
to spill over into the next part of the garage, which would become attached by virtue of having the walls. I think this is why it's in front of us tonight. It's a poor, maybe our zoning ordinance definition is not well-defined to say with walls or without. It does say walls, comma, I think it says floor, comma, and roof. So it is a very difficult, and I had to struggle with that, to say, well, I don't think, further on, when I read into the actual body of the language in 16.1 C.1, that that's really not the character of duplex. And that's what I'm saying, that I don't think that satisfies that intent.
Just to follow up with that, I do tend to agree, and some of the other ones, whether on Greeley Street or Burns Hill or whatever, I'm not sure if the one on Greeley Street house listed on our tax maps and things like that, so that's another story, but definitely from aesthetic-wise is not what we're looking for either, so walls, connected houses, they look together. And from that property, it's hard to see that area anyway, it's stuck back, it's down a little bit, you know, people wouldn't notice it
Yeah.
unless they're really looking type stuff, and that's not the point, but if it was all connected, it would look like one big house, or, which could be a two-family in some regards, so.
The only comment that I want to make is, from Mr. Buttrick, I don't think that there's anything bad about our zoning ordinance. I just don't think it's kept up with the times. I think people are trying to look for alternative housing markets, if you will.
Yeah, I meant,
Because children are staying home longer and people are aging longer
I
and,
don't say that.
They're not staying home? Oh, they're staying home. And they're aging in place. I mean, they're not going anywhere because they have the children to take care of them. So I think we just,
We're always updating and reviewing our ordinance,
Exactly.
and it's
yeah.
an ordinance in progress,
I
but
should say, it's a bad one for me to enforce and interpret from a practical standpoint, I guess is what I should have said. Not necessarily it's a bad ordinance, it's bad for me to apply it.
Interpretation and
Right,
apply,
right.
right. And then just to follow, oh, go ahead.
go ahead. Do you have another?
Yes.
Go ahead.
Yes, I just had one question, Mr. Buttrick. Those two properties that were mentioned on Greeley, did you get a chance to look at that? Do you know if they went through the process of the planning board, or?
I think there was a variance, there was some history on, at least a building permit on the Greeley Street. At the Burns Hill one, I don't know, I wasn't aware of that
I
one.
think Burns Hill is listed as condos.
Oh, condex.
That's what I
Yeah.
think.
Well,
because
that's
of condos.
ownership. Yes,
It
it's
looks
still-
clear that it was built as a duplex with that connector, because the roof line, everything is, go ahead.
I just want to point out to the board, Mr. Chairman, HCO 3346 definitions duplex, two dwelling units attached by any portion of one or more floors, walls, or roofs. And then 33416C1, conditions of issuance. No permit, however, shall be issued unless the structure will present a reasonable appearance and will be in keeping with the neighborhood unless the building is to be finished on the exterior in a permanent manner. And then where I'm going with this is, you have a definition saying one thing, which is what he wants, and then another part of the ordinance telling you something different.
It does say walls in the first part.
No, it says walls and the roof, I was assuming that it's the same
So-
roof
It's either
of the
or,
duplex.
it's
It's
and.
conflicting.
Yeah,
Right.
it's
but
not
I-
the
I
overhang.
think the condition here, let's continue talking.
Thank you.
Go ahead.
Why wouldn't a solution be to create a living area over the garage?
Small.
Isn't there one?
No, there's no living area above the
So
garage
it's
right
all an
now.
open
It was
room.
just storage.
Oh, behind it, I got
Yeah,
it.
but you're still a separate unit, you're still, how do you identify as a living area in a separate building?
I was just wondering, I was just asking the question. I didn't, yeah, I just wanted to know why they wouldn't use that space, because it would
They
be,
might later on, because once you put the two-family, they can go up in that space easily. I would think that's what they'd do anyway, but, because there's no restriction on square footage, it's not an assisted living type situation, so.
There may be some conflicting things, but we're talking extremes here, and what's the limit of the extreme that we, and that's why it's before the board. Go
I
ahead.
have one question on this, this diagram. What is this area behind the existing garage and the proposed duplex? There's no title.
There was, at one point when the Dollettes bought the place, that was already built, on the back of the garage. It's, I wanna say 11 by like 46 feet,
Was
something like
it
that.
storage?
It was just part of the garage,
Part of the garage?
yeah. It was existing.
so, could I just ask, what's the, if hypothetically, if the board decides that we would have made the same decision and the zoning administrator's determination is upheld, do they need to come back for a variance from the ordinance or special exception? What would it be?
Well, it's their choice. They could possibly pursue an ADU, make that work.
Without the connector, yeah.
Possibly create two dwelling units, having to go then to planning board for site plan, two separate standalone dwelling units. I don't know what other options, I mean, whatever the owner would wanna do.
Go ahead.
Would a third option be building a little more of a structure between the two, like I kinda suggested earlier, where it's enclosed in with, so it's connecting?
Yeah, and that's probably a possibility as well.
Away from the street, it looks a continuous unit.
Correct.
Two-family.
Correct.
It's got the walls, it's got most of those criteria that we're looking for in the,
I think an architectural feature to make it look more like a continuous, either one building, even though it's still a real true duplex, because of the offsets, what makes it difficult to make that really a true duplex.
There's some options there.
It's really an architectural detail for the owner.
Okay.
Would I accept that? Probably, if it was
You
too.
I
can't
think-
really see the back from the street at all, to be honest with you.
Note taken, but now it's before the board. I think we'll keep it there.
Yeah.
Okay. I mean, I'll add that 2-foot overlapping dimension with one single roof, to me, is a very extreme interpretation of a duplex. Very extreme. And I think was read that architectural pleasing or should look, this to me doesn't, it's so minimal to show, it's almost like stretching a ladder across from one to the other and putting tin on the top. You know, there's some point where it just doesn't fit.
Yeah.
And I think this, in my mind, this far exceeds the point where it doesn't fit. I would agree with the zoning administrator that more can be done to make these two buildings connected and look together, whether they're closed in or not. We have cases where the garages are open, but they do look like a continuation of a single unit and fairly nice looking. So I
More
think
like a breezeway, where you'd walk in and go to
Yeah,
either unit,
it could be, and I think
something to that effect.
these are big structures in themselves, and this is much more can be done. Otherwise, if this was considered a duplex, I would fear that nothing would be considered in the future not a duplex. That's the way I look at it. My feeling on it. At some point, we need to,
Particularly where you have other examples around town in numerous different areas where we have required them to
I
look.
think in fairness, do we have an example like this in town? Anybody know?
Greeley Street.
Well, that one on Greeley Street's similar.
Yes.
It's not oriented same way, but
I
it's.
mean, but we're stepping a couple steps further back here.
Right.
That's what I think. Maybe that's since it's there and whatever happened. Anybody else know of cases that look like this? Close? No?
Right here at the bottom of Pelham, 46 Pelham. That's horrible in my eyes.
I would agree, we probably do have cases of horrible conditions.
Yeah, but we don't know, I mean, we can't do that because we don't know whether that's even something that's been permitted or not.
Agreed,
At this
and,
point.
and, you know, I was just saying, this is an extreme case, there may be a couple others, I don't know, but maybe they shouldn't be either, and that's where, and why things come to the zoning board, and why you use your judgment. Anyway, that's my feeling. Any more comments? Any,
No, but just for the record, we should make note of that, Mr. Buttrick,
right,
that example.
it's not, it's,
I don't have any other comments. I'm
it's pretty
prepared to make
close, but I don't like that one either, so.
Mm.
Anybody willing to make a motion?
I have one more question. When you're talking in closing, are you talking like just a 3-season porch? Are you talking finished sheet rock if they were to enclose that structure?
I just think it needs something more. It could be 3-season, it could be, in the case, the one on Burns Hill, it's a garage. More than a carport, but it's a garage connection, and it works. It's just, each case I would think is a little
It's on there,
different.
mhm.
This is offset, so it's more complicated, and maybe it does need an architectural look at it to make it look nice.
Well, I know the one on Greeley Street is an eyesore if you look at it, because
Yeah.
it looks out of place. It just says, you know, why would somebody put a connecting roof between two buildings with nothing in between?
Yeah, and I don't think we should be looking to see that as what we want in our town. I guess that's what I'd say.
But I mean, what's before us is whether we would have made the same decision as the zoning administrator if it was presented to us. I'm prepared to make a motion.
Go ahead.
I'm making a motion to uphold the zoning administrator's determination that we do need more than just this minor connection between the two, and that we need something more to make it be a duplex, to keep in character for the rest of what's expected in
So
town.
the issue is the minimization of this, not the fact that it's considered, they want to consider it a duplex, it's just the approach they took.
Exactly.
Okay. Anybody second?
I'll second that motion.
Mr. Petrie?
I do think that the end goal for the applicant is available to them in the end. The application as submitted right now doesn't meet the criteria as a duplex as we see it, but the end goal is an option to them, for changing a little bit, I think.
Poll the board?
Ms. Davis?
To uphold the zoning administrator's decision.
Mr. Petrie?
To uphold.
Mr. Dearborn?
To uphold,
And Mr. Hool, I would have voted not to uphold. And Mr. Brackett?
To uphold. Vote is 4-1. Therefore, we uphold the zoning administrator's decision. I think just as a clarity, the vote and interpretation of that is what we see versus the fact that you want to make a duplex here. If that helps clear things up for you, I hope it does, you know.
Could go either way. It's like, where do we end, where do we start? You know what I mean? It's like I explained earlier, there's no
We
real,
understand.
no real terminology on a duplex. There's no real pictures, no real blueprints. We're just used to the two-door shotgun. That's traditional. But if you look all across everywhere, you go to Chicago, you go to Australia, there's different style duplexes. So there's not real one set duplex,
There's
how
not.
they're connected by a roof wall or a floor. So, you know, that's where,
I understand.
what I
So-
was trying to do was gonna be a real nice looking piece of architecture, connect both buildings. I'm not gonna slap a piece of wood up there and call it day. It's gonna be real nice trellis ends, pine tongue groove with tin roof, with nice, you know, real nice looking. They'll look nice with what they have back there with the scenery. Wasn't gonna be, I mean, anything horrible. You really can't see the structure from the street.
Understood. I think you have an opportunity to maybe do a little more, do it a little different, and
Okay.
come back. So we're not saying don't come back.
Okay.
Exactly.
All right, thank you.
Okay, thanks. Read the next case, if you would.
Case 174-168, May 24th, 2018. Another Beautiful Day, LLC, care of Attorney Jeffrey A. Zoll, Post Office Box 3652, Nashua, New Hampshire. Request the following variances at 3 Highland Street, Hudson, New Hampshire. A variance to allow a 4-unit multifamily dwelling in a TR zoning district. Map 174, Lot 168, Zone TR, Hudson Zoning Ordinance, Article 5, Section 334-20. Allowed uses provide in tables. And B, a variance to allow a 4-unit multifamily dwelling on a lot consisting of 16,354 square feet buildable lot area, where 58,560 square feet of buildable lot area is required. Map 174, Lot 168, Zone TR, the Hudson zoning Article 7, Section 334-27, table of minimum dimensional requirements.
Any background or explanation?
Basically, the request is for two variances to build a four-unit where only single-family units are allowed, and the proposed four-unit would not satisfy footnote number 2 in the table of the minimal dimensional requirements, which requires a lot size of 58,568 square feet, and the lot only having 16,944 square feet available.
Okay. Who's here to speak on the?
Good evening. My name is Jeffrey Zoll. I'm an attorney with offices at 221 Main Street in Nashua. My last name is spelled Z-A-L-L. I represent the applicant, Another Beautiful Day LLC. Before I begin, I have some material that I would like to pass out because I'll be speaking with reference to the information that's in this material, and it might be helpful
Sure.
for you. Let's see, 1, 2, 3, 4, 5, 6, 7, 8, and...
And you don't need this back, right?
No, I've got my own.
Before we start, do you want to hear both these at once? They're all interrelated. Anybody?
I think we vote on them separately.
I agree. And no problem hearing them at the same time, right?
I'm okay with that, but obviously vote separately.
Mary Ellen?
I'm okay.
Yeah,
I was
okay.
just getting
We'll hear 'em
nervous.
both
I couldn't
the same.
find my other
Yeah, I
decision
have my
sheet.
preparation ready to do both of them at the same time anyway. I thought
That's
that would
fine.
make
It-
more sense.
Give the board an opportunity to make their decision.
As I said, the applicant is Another Beautiful Day LLC. The property that's subject to these variances is at 3 Highland Street. It's a two-family building that has been unoccupied for a long time. It's in terrible condition and needs to be torn down. These are pictures of the property. The applicant is proposing to tear down the building and replace it with a 4-unit townhouse building with units of approximately 1,100 square feet to about 1,300 square feet. This is basically what the applicant is proposing the townhouse to look like. You have a plan according, with your materials that we submitted with a variance application that shows the site plan and where the townhouse and the driveway and the parking will be located on the lot. If the board grants the variances, the applicant will then be required to obtain site plan approval from the planning board because anything over a two-family residential structure needs site plan approval. This property is located in the TR, Town Residential District, and the only residential use that's allowed in that zone are single-family dwellings, older persons' housing, or assisted living facilities. Two-family dwellings and multifamily dwellings are not permitted uses within the TR zone. Even though not permitted, there are numerous 2, 3, 4, or more unit multifamily buildings are located in the TR zone, and especially in the neighborhood surrounding this property at 3 Highland Street. Within the TR zone, along Ferry Street, Highland Street, Library Street, and Central Street, there are at least 25 properties that are multi-unit properties. And by multi-unit, I mean 2 units or more. On Library and Highland Street, from Library Street to Pleasant Street along Highland Street, there are 8 out of 11 properties, 8 out of 11 residential properties that are multi-unit properties having from 2 units to 6 units. On the material that I submitted to you to look at, if you take a look at the second plan on the 4th page, counting the cover page, you'll see in that area from the beginning of Highland Street and Library Street to Pleasant Street, 8 out of the 11 properties there are all multi-unit properties. On the 4 properties on Library Street and Highland Street that abut this property, immediately abut this property, all 4 have 2 or more units. The properties on each side of this unit, the property at, on Library Street is a 6-unit property. It's 5 units of townhouses, it's a condo, but it's 5 units of townhouses, and in behind it, on the same lot, is another unit that's detached. On the other side of the property, well, actually, and right next to that, on Library Street, and abutting the back side of this property, there's a 4-unit building. On the other side of the property, on the easterly side of this property, at 5 Highland Street, there's a 3-unit building. Across the street, there's a commercial property and a 2-unit building. These maps and density calculations that are in the material that I provided for you show that the immediate area is predominantly made up of non-conforming multi-unit residential properties, and that the densities of those properties have square footage per unit that are generally less than the square footage per unit proposed for the 3 Highland Street property. The proposed square footage for this development is 4,086 square feet per unit, 4,086 square feet per unit. We have 2 variances requests. The first is to allow a 4-unit multifamily dwelling in the TR zone. This variance will not be contrary to the public interest and will observe the spirit of the ordinance, because the essential character of the neighborhood is that it's primarily made up of multi-unit residential properties. The proposed use as a 4-family dwelling will be consistent with the neighborhood. It will not threaten public safety, health, or otherwise injure public rights. The general purpose of the zoning ordinance is to maintain consistency of uses within a neighborhood. And the applicant is asking for a use that is in fact consistent with the abutting properties in the general neighborhood on Highland Street. Substantial justice will be done, because by allowing the multifamily use, the applicant will not be subject to a greater restriction than that imposed upon the neighboring properties. And there will be no harm suffered by the general public or other individuals. The proposed use will not diminish value of the surrounding properties, because surrounding properties are mostly multifamily properties. Right now, the property is an eyesore, and its development will be better for the neighborhood. In the packet of materials that I prepared for you on the last page, there is a letter from Donald Gingras Realty Company by Donald Gingras, who is a very experienced real estate broker and agent in this area, and he provides his opinion that development of this property will only enhance property values. Now, because of the special conditions of this property, the restriction applied to this property by the ordinance does not serve the purpose of the restrictions in a fair and reasonable manner. To say to the owner of 3 Highland Street that you can only have a single-family dwelling because that's what the ordinance allows is not fair. It's not reasonable. Not when there are so many multiple unit properties in the neighborhood and in the wider TR zone. And it's especially not fair and reasonable when the property is surrounded by a 6-unit property, a 4-unit property, and a 3-unit property immediately abutting all the sides of the property. That's the special condition that exists, such that the literal enforcement of the ordinance results in an unnecessary hardship. The restriction that is applied to the property by the ordinance does not serve the purpose of the restriction in a fair and reasonable manner, and that's the requirements of a variance. Furthermore, the proposed use of a multifamily dwelling is a reasonable use, because it fits in with the character of the neighborhood. The second variance is predicated on the first variance being granted. Now, if approved, the next restriction imposed on the property is the minimum lot area or density requirements of the ordinance. Now, for multifamily properties, the ordinance requires 53,560 square feet of buildable lot area for 3 attached units, with each additional unit requiring an additional 5,000 square feet. Now, since the only zone where multifamily is allowed is the business zone, and where the minimum lot area in that zone is 43,560 square feet, or an acre, or 30,000 square feet where there's water and sewer, applying the minimum square footage in that section of the ordinance, which is note 2 on attachment 4, applying that requirement makes sense. However, I don't think that it makes sense for a multifamily property in a TR zone that is permitted by a variance. In a TR zone, a single-family property needs a lot of 10,000 square feet minimum. But if you apply the minimum lot size for multifamily and a two-unit property would require 43,560 square feet. A three-unit property would require, on a per-unit basis, 17,853 square feet per unit. A four-unit property would require 14,640 square feet per unit. So to the extent that the table of minimum dimensional requirements under Section 334, Section 27, Attachment 4, Note 2 of the ordinance applies to a multifamily that is allowed by variance in a zone other than a business zone, we are requesting that the variance to allow 4 units in this lot consisting of 16,354 square feet. That is, I don't think that the minimum square footage in the ordinance would apply to a variance that's granted to allow a multifamily somewhere other than in a business zone, because that note 2, specifically applies to the business zone, the permitted use in the business zone. Multifamilies are not a permitted use anywhere else, just there. So it makes sense in the business zone because the basis of the underlying lot is so large that you add 5,000 square feet for each other additional unit. You start with 1 acre, 43,560 for the third, for 2 units. The third unit goes to, 43,560 for one, and then 5,000 for each additional unit. So now for a 4-unit, you're up to 58,560. So I don't think that applies. But to the extent that it does apply, we're asking that you grant a variance for the minimum lot area or density requirement for this unit. Now, the facts that support the first variance also support the second variance. It will not be contrary to the public interest and will observe the spirit of the ordinance, because most of the lot sizes for the multi-unit properties in the neighborhood, and particularly of the abutting properties on Library Street and Highland Street, are less square footage per unit than what is proposed for 3 Highland Street. Now, in the materials that I provided for you, there are 2 charts. One chart on the third page has the neighborhood densities of the abutting properties, of the 4 abutting properties. The chart on the 5th page has the neighborhood densities for the neighborhood that runs from the beginning of Highland Street and Library Street to Pleasant Street. In that chart, I've got the number of units, the lot sizes, and what the density is, the square footage per unit. The first one is for abutting properties, as I said. The applicant is proposing a density of 4,086 square feet per unit, while the abutting properties have density ranging from 1,793 square feet per unit up to 6,287 square feet per unit. Now, the average density of those 4 properties that abut and surround this property is 3,037 square feet per unit. And the applicant is looking for a development with greater square footage per unit at 4,086 square feet per unit. Now, in the wider neighborhood, as shown on the second chart, the densities of multi-unit properties range from 1,793 square feet per unit to 7,078 square feet per unit, except for a 2-family property that is located at 16 Highland Street. And you can see that property on the map that's just before that, page that's just before that, where I outlined what I considered a reasonable neighborhood for comparison purposes in blue. The subject property is in yellow. And the last lot in the upper right is a 1.377 acre lot at 16 Highland Street. Now, where it's in a TR zone with a minimum lot size of 10,000 square feet is the norm, I discounted that lot as an aberration. That lot is 1.377 acres, whereas the minimum lot size is less than a quarter of an acre. So in my calculations, to give you an idea of what I thought was a reasonable average density in the neighborhood, I removed that from the calculations, because as I said, I thought it was an aberration. So they run from 1,793 square feet to 7,078 square feet, which has an average density of 3,789 square feet per unit. Once again, that density has less square feet per unit than what the applicant is looking for his property. The density proposed by the applicant has more square feet per unit than the average density of the multi-unit properties. Substantial justice will be done because the density on this property will be consistent with the densities in the neighborhood, and there'll be no harm to the general public or to other individuals. Values of surrounding properties will not be diminished, and the restrictions applied to this property by the ordinance do not serve the purpose of the restriction in a fair and reasonable way. To say to the owner again that your lot requires 58,560 square feet, or a density of 14,640 square feet per unit, when the average densities per unit in the abutting properties is 3,037 square feet, and in the wider neighborhood, the average density is still smaller, at 3,789 square feet per unit, to say that to the applicant and to hold his feet to the fire on that would be unfair and unreasonable. Density minimum lot area for the multifamily requirement as applied to this property, if in fact it does apply to this property, does not serve the purpose of the restriction in a fair and reasonable way. The proposed use for the property is a 4-unit dwelling of 16,354 square feet is reasonable. Now, the applicant has discussed his proposal with most of the neighborhood lot owners, the ones that he could find when he knocked on all the doors. There are some lot owners who don't live there and lived in other parts of the state, and most of those he could not discuss it with. And those lot owners have expressed their support of this, and I have 1, 2, 3, 15 of the lot owners in the immediate area, which is most of the affected lot owners who are butters, either direct or non-direct, expressing that their support. And I'll read, they've all signed this form, and I'm gonna submit that, but I'll read it to you. The purpose of this document is to reach out and get the abutters' opinion on the proposed building plan for 3 Highland Street, Hudson, New Hampshire. Our goal is to demolish the vacant, dilapidated structure currently existing at 3 Highland Street, Hudson, New Hampshire. We intend to build 4 modest-sized attached townhouses of approximately 1,100 to 1,300 square feet. Based on our research, we believe this project will improve the surrounding property values and bring life back to the existing lot that has been a neglected hazard for a long time. We have applied to the Hudson Zoning Board for a variance to allow this project to proceed. By signing this form, you state that you agree to the proposed plans as mentioned above and do not oppose the project. You authorize us to present this form to the zoning board to show that you do not oppose the variance. I'd like to submit these for the
Please,
record.
yeah.
Thank you.
That conclude your
That
test?
concludes my presentation.
Is there anybody else like to speak in favor of the applicant? Seeing no one, is there anybody who wishes to speak neutrally or in opposition? Seeing no one again, nope, excuse me. I couldn't see you behind the board, I'm sorry.
I couldn't see the board, so I don't know
Well,
what he's.
come around, look.
I'm sorry.
Thank you. I'm a direct abutter.
Please go to the podium and introduce yourself. Spell your name if you would.
Good evening, I'm Stuart Schneiderman, and I own number 2 Library Street. And I don't know if this is a premature question, but this may...
Please spell your name first, though.
Oh, sure, S-T-U-A-R-T. S-C-H...
Oh, no, last name is,
N-E-I-D-E-R-M-A-N.
thank you.
Cool.
But go ahead.
I don't know if this question is premature, and whether it should be more of a planning board question, but I am concerned about runoff because of the footprint.
It would be planning board.
Okay, then I will address it then.
Yep.
And hopefully there'll be some engineering studies that will give answers. Thank you very much for your
People that
time.
know more. Is that it?
That's
Yeah,
pretty much it.
We're more interested in the legal applications of the land, so,
Thank you very much indeed.
thank you.
If I just may briefly respond. yeah.
Oh, if you'd like to,
Yeah,
sure.
there will be site plan presented to the planning board, prepared by an engineering firm, and they will address all those things. The site plan regulations will require engineering detail on a runoff to make sure that there's not an issue.
Okay, I'll just add to that, that the planning board has the right to go to professional services and have that reviewed to be consistent with what we expect in the town. So. But it is the planning board that you should be addressing that to. Yep. Anybody else that wishes to speak neutrally in opposition? I apologize. It's a nice board, but I can't see behind it.
It's usually over here.
Is there one?
No, usually put them over here.
Oh, well.
Yeah, we usually do, but. wanted it
Okay,
close
now
to me.
seeing no one, I'll declare it before the board for discussion. Go ahead.
A couple
Mr.
of
Dearborn?
comments. Matter of fact, I lived exactly across the street from 3 Highland Street for 5 years. And every one of the houses that you're stating here, 2 and 3 tenements, are all been there for many, many years, okay? Matter of fact, my brother owned the one at 5 Highland Street, which was a 2 tenement at that time he owned it. Now it's a 3, I see by your records. I also been informed by someone who lived at 9 Highland Street. He applied for a 3rd apartment at 9 Highland Street some years ago and was turned down, strictly because it was a TR zone, okay? The house, I have a concern with the parking here. I guess my understanding is that for every apartment there's 1.5 cars. I can only see 4 cars parked here. How do you propose to have, say, 6 cars? I remember this piece of property when it was a 2 tenement, and they had trouble parking then, at that point in time, when it was a 2 tenement. Now, with 4 apartments, and let's say 6 cars, is there enough room for 6 cars here?
I think that though, first of all, those issues will be taken care of at the site plan review stage, but, it would seem to me that you would count a parking space inside the garage and one behind it. I'm not really knowledgeable about the site plan regulations for parking in the town of Hudson.
This, I would agree that it's a site plan issue
Yeah.
for the planning board, but
I-
your answer generally, given there's no real design yet,
No,
may
there
be
is, there's
appropriate.
no real design yet, but it will be designed so that there's significant, enough parking to meet the Hudson requirements.
And I know this planning board is
Yeah.
pretty focused on reviewing plans specific, so.
Yes. When I asked the applicant to provide us with a sample of what he wanted it to look like, it wasn't designed yet for this site.
Yeah.
This was the type of thing we want to have. The type of parking that's shown here, or the type of parking that's shown on the proposed site plan that's attached to the application, isn't the design of this property yet. It will be designed in accordance with town regulations, though.
So it's, thanks for your answer, and
Thank you.
they'll go to
And
the
also,
planning board.
to respond to one other thing, I know that you, I know that all those properties that are around it are all before the TR zone. They're all
Many,
grandfathered.
many years prior to
And this
it.
one was too.
Yes, oh, yes.
But I know that all of those are old properties.
Yep.
All throughout the TR zone, there's a lot of multi-unit properties, and they're all old.
Yep. I agree.
Agreed. Other questions?
Not questions, just
Petrie?
comments.
Comments is fine, yeah.
Yeah, that area is one of the oldest areas in town, that area up north side of like Benson, where the town hall used to be and stuff. I have some concerns too, that you can say are gonna be planning board, but this is a land use one, because the side setback, you're right at 15 feet, and there's gotta be a back door for each one of those units. And at some point, they're gonna build a landing or a deck, and then it becomes a setback issue, and it comes right back in front of us again. I know the planning board does a great job, it's not my question, but when I see that, I'm saying, you know what, I'm gonna see this garbage again, and the homeowner's gonna come in and yell at us, and we're gonna say, the builder maximized this lot, and you most certainly have with a 4-unit and a TR in that old area of town. Just my comments.
We had that very specific case on Kimball Hill where they came in, and I know some got approved and some didn't, so.
And Provincial
Interesting
Heights,
point for the planning board to consider.
We can agree to a stipulation that there will be no structures built into the setbacks, side yard, front yard, or rear yard.
You don't have to, because it's not allowed.
Well, I understand that, but if it,
but it happens after it's
it
built. no one
happens
cares,
afterwards, and
it happens anyway.
that's what this gentleman was concerned about, and I can understand that.
Happens
And it's gonna probably be a condominium, so we can write that into the condominium documents so that each unit owner knows that at the same time.
How's
But
the board feel?
We're not there yet.
Okay. Go ahead.
I think I have a comment and a question for the applicant. So my comment is that all the examples that were given are existing non-conforming uses.
Agreed.
They were all there before the TR zone was created. So what we're being asked to do is to create to tear down a non-conforming structure and create another non-conforming structure. But that non-conforming use, all right, I always say structure, the non-conforming use.
Agreed.
But that new non-conforming use is even more non-conforming than what had been existing, and more non-conforming than almost everything that's in that neighborhood. So it's not with keeping of the neighborhood.
Understood. I would offer for discussion is that we had a case recently where I studied the Simplex case. And this smells of the Simplex case, where there's non-conforming uses and in the immediate area, and this is surrounded by those. So I offer that up as something to consider. You're right, it's more non-conforming, but it's not as non-conforming as the ones right next to it, for instance. And the case, I thought the applicant's attorney made a pretty good case for square footage usage of the lot. And that can be an argument for the Simplex issue. So I just leave it there. I do understand what you're saying, and I would offer that I would feel more comfortable if every one of those houses was one small lot with one small house on it, but it's not. And as you move away from this corner of downtown here, they become more conforming to the TR zone. So this is agreed. It's preceded the issue, but it's
the intensity of the use that I struggle with, and
I
I wonder
understand.
if that's
I'm
really,
just offering a
you know,
counter
to the
discussion.
benefit of the public, or is it to the benefit of the applicant for, to max out the land to the point of,
I agree, but he's
Extreme
using a good
density.
argument, given the one next to it's only less than 2,000 per square feet per unit.
That one's so old and built
but
before
that's,
any
it
of
was
this.
built before
Yeah,
even
right.
zoning was in place in the
I
town.
agree.
Right, and.
It's
and-
there, though.
Exactly, yeah.
That's the issue.
Yeah.
Okay. Something to balance an argument or
Mm-hmm.
add more to it. Go ahead.
In the testimony, one of the hardship stated was that we were limiting his client on building on the property. We're limiting to what he wants to do. He has options. And to go along the lines what you said, there's already existing two-family there. And if he came in building a nice two-family that wasn't impactful on all the setbacks and everything else, I think we might have been a little more open, might be a little more looking at it, saying, hey, you know what, it's better in the neighborhood, makes it look better than it was there before, he's gonna get some income out of it, whatever he wants to do, but we're not impeding him, we're just impeding him for the extent of the density he's looking for. So I don't think that's a hardship.
Again, I refer to the Simplex case where it definitely was overturned on those issues.
We don't do bullshit and Simplex anymore, so it's good.
Well,
We could, they could fight it, but
go ahead.
No, I
Something
don't
to
have
talk
anything.
about.
No, I don't think I have anything else.
Anybody else? Any comments? Motions?
Could I respond to what was suggested or what was said?
Up to the board. I know it's before the board, but do you want to hear any more comments?
Yeah, sure. I don't think there's anybody else here that's
Go
going
ahead.
to.
Yeah, I just wanted to respond to two things. First of all, your concern that it was an expansion of a non-conforming use, and yes, it absolutely is, but that's what requires a variance, when you expand a non-conforming use. That's why we're here, to expand it. That's the variance requirement. To your concern about, we're saying that you are denying him to use his property to maximize it. It's not that. The hardship is well-defined in the Simplex case and well-defined in your ordinance and your application, that if the restriction in the ordinance does not if the relationship between a restriction in the ordinance and this property does not result in a fair and reasonable way, then that is the hardship. It's not like it used to be years ago when I first started practicing law, where we had to say, well, the hardship was the shape of the lot or the contours, and we really had a hard time trying to figure out what hardship was. And nobody really knew. Since the Simplex case, hardship has been really well defined, that if there's no reasonable connection, reasonable and fair connection between that restriction and its application to this property, because of its location in the neighborhood, then that is a hardship. And that was my argument, that you're surrounded by 6 units, 4 units, 3 units, 2 units, all of which, the majority of which, have densities with far less square footage than what we're looking for. That means that that restriction is not reasonable and fair when applied to this property. You know, the density could have, 5 or 6 units probably would have come out with a density that was closer to the area densities. But this applicant has decided that this lot is best developed in 4 units. You know, that's all I really have to say.
Motion?
I'll make a motion to deny.
Second?
I'm seconding.
Speak on your motion.
On its face, a multifamily is not allowed in a TR zone. There is multifamily there currently, which is non-conforming, and if they were to equal this current non-conforming, I think my decision would be a little more open-minded. And having a 4-unit is just too intensive of a use for that property for 16,000 square feet.
Okay, second?
I would agree with Mr. Petrie, and I would just add that I think that the 4-unit is not within the spirit of the ordinance and what the intent of the TR zone was meant to be. And where the surrounding properties are non-conforming, we would expect any kind of change to those uses to be conforming within the ordinance. I don't think that this really meets the hardship in my mind, from a use perspective, from the land use perspective. And I think that the intensity of the use is not keeping within the spirit of the ordinance or the surrounding neighborhood. Those uses aren't maxed out, and we have had situations on that very same street where we have not allowed expansions of the 2-family uses.
I guess I'm gonna speak. I'm gonna vote in opposition. When I first saw these properties and first saw the case in our packets, I said, gee, this is pretty clear. What an extended use of the property, much bigger. But then seeing these properties around it, and even if these properties were further away from the applicant's property, I would feel better about voting against it, but they're right next to it. And the hardship of the property is being treated different than the neighboring properties in this case. And that's the essence of the Simplex case. Even in place where the Simplex case was a commercial to industrial to commercial, there was never an argument to remove those other commercial properties, but the argument was that this is similar commercial use to those other commercial properties in an industrial zone. And without putting the labels on it, it's the same case in my mind. This is, you got a 6, 4, and a 3 surrounding this property, locking it in, and I don't see us being able to withstand an appeal on this, but, so I'm gonna vote against it.
You're gonna vote against our motion.
Agreed.
Which means you're gonna vote to grant it.
Yeah, I'm against the motion, yeah,
Yep,
exactly.
okay.
Okay, pull the board.
Mr. Petrie,
Not to grant.
Ms. Davis,
Not to grant.
Mr. Dearborn,
Not to grant.
Mr. Hool votes not to grant, and Mr. Brackett.
I vote to grant. Seeing the vote is,
So that's
4
on
to
both,
1.
right? Just for clarity, it's on
A
both
and
for
B.
the variance, for the four-family, for,
agreed,
And
it's
the
on
TI
A,
and-
part A.
On A only.
A only.
Only.
When we said he can trial his on both, but we'll hear him separately, is what we said.
We
earlier.
agreed to that in the beginning, and then
Wasn't
I
total.
think for procedure-wise, we need to vote on the second part.
I would concur.
Seeing the vote, 4 to 1, your variance is denied.
The 4-to-1 vote was on the multifamily, so you didn't address the density issue.
Agreed. We're gonna address that next.
May I ask the board that if the request was reduced to 3 units, would the board be more favorable on the multifamily? And we'd be prepared to make an amendment this evening if the board would be more favorable to approving a 3-unit.
I understand. I'm not sure, since it was advertised, that we may have a problem hearing it. We can have a discussion, I think, if you like, but there'd be no motion on that tonight, right?
correct.
We
'cause
can't
have
make a
to-
motion on it, we can discuss it briefly, but it's irrelevant in
It's a
some
brand new,
regards.
I would think it would be a brand-new application.
Yeah,
right?
it would have to be, but I think for your benefit, I wouldn't mind hearing some discussion.
I would like
on
to
it.
hear the thoughts on it.
Maybe we don't wanna speak too much, but there might be
Yeah,
some
that's,
comment.
that's your catch 22 on that one a little bit, but
Go ahead, anybody wanna speak? Mr.
I think
Dearborn?
it's better than what's in
The
front
only
of us.
thing, I would vote to oppose even 3 units, because I was told that person at 9 Highland Street applied for a 3rd apartment back some time ago and was denied because of being in a TR zone.
But
And
was
it
he,
was currently
did he
2.
seek a variance, or was he just denied at the,
I don't know
You
the
don't know.
I think we'd
details.
have
I
to
was
look
told.
into that, and
That's a-
there,
Yeah,
big
Yeah.
question?
And I'm not sure if all those multi-units in there are all,
yeah. It's a 2-tenement
On the
house
tax
right
map,
now.
right.
any other
So-
discussion?
I would definitely entertain a 2 or 3 family.
Okay.
correct.
Because I think that the 3-family has less impact on the overall square footage of the lot, and that allows for a better use of it,
Okay.
both aesthetically and
Impact.
impact and planning board considerations.
Okay. I can
The other
agree
thing
with
that this is planning board, but things that I get concerned about is that that's right by the street light, and it's a rough in and out for traffic. I know traffic is planning, parking is planning, I know all that. I'm just saying that I think that the intensity of the use with the 4-family is just, it's unrealistic to
Oh,
me, it's
okay.
unreasonable.
Well, that's fine, so you
So
might
I would
be,
entertain, if they came back with a 3-family, 2-family, 3-family,
that out, okay. You up, go ahead.
Moving the discussion on, I think, because it's proper at this point. would B be considered to withdraw without prejudice if he wanted to, or do we have to hear that at this point?
No, I would withdraw that without prejudice,
That's
because if
fine.
you've
Yeah.
denied the
Correct.
multifamily use in the zone, the density issue is academic, so
Correct.
I will withdraw that.
You wanna, do you have anything further to say
No, sir?
about 3 or 4?
We just discussed it briefly.
2 or 3, we didn't,
Well, you don't like 4, but would you like 3 or?
We can't make that statement until we look at the impact in the drawings.
Okay,
But
that's
yes, people. can do
understood, you don't have
obviously,
to,
'cause it's
you don't have
more-
to answer, that's
Yeah.
fine.
yeah, because they could come back, no offense, they could come back with a 3-unit, that each unit is bigger.
They're now 2,000
So
square
that,
feet.
yeah,
No,
so I'd
it-
have to see what the
I
plans
know.
are
I
and
understand
see
your
what's
concern
reasonable to me.
is maximizing the area in the lot, and that won't be the case. It'll be a
Just like
smaller
when
footprint.
properties are in the setback, or on
Be a
the edge of
smaller
the setback, it always comes back. And I know the planning board addresses them, but it always comes back to us where someone puts a porch back there or a shed, and,
Oh, reasonableness of what is,
We have a motion for the withdrawal?
I do,
you know, yeah,
I make a,
well, I
yeah, we
suggested
both.
it to the applicant, he agreed.
Okay, and Mary Ellen seconds.
All right.
yeah,
Vote
Petrie and Diggs.
procedurally, all in favor, say aye.
Aye.
Thank you.
Thank you, we'll be back.
Okay.
Good luck, thank you.
Moving along pretty well. Anybody need a break or?
I do.
You don't need the decision sheets on the withdrawal.
No. 8:26, I adjourn the meeting for 10 minutes. At 8:34, I declare the meeting back in session. Will the zoning administrator read the 4th case into the record?
Case 174-119, May 24th, 2018. Kevin Allard of Pathway Homes, Inc., 79 Cortlandt Drive, Bedford, New Hampshire, requests a variance at 76 Highland Street, Hudson, New Hampshire, to allow the subdivision of one residential lot into 2 residential lots consisting of 75 feet of frontage each, where 90 feet of frontage each is required. Map 174, Lot 119, Zone TR, Hudson Zoning Ordinance Article 7, Section 334-27, Table of Minimum Dimensional Requirements.
Who's here to speak on that?
Me, Kevin Allard.
Oh, wait a minute. Our recorder's
There's a
missing.
recorder.
Recorder.
Can we just hold a minute? I apologize. I didn't know she was missing.
I think she's in the restroom.
Yeah, she's. We'll all stare at her when she comes
Oh,
back.
she's falling down the stairs.
Yeah, sound like
No,
it.
she's already in there.
No, I understand. I was being,
Get me in trouble already. Get yelled at.
again, for the record, would you state your name and spell it for us?
Kevin Allard, Allard.
And if you'd present your case?
Okay, I'm just gonna give a quick background of how I landed here tonight. I purchased a property on 76 Highland Street in Hudson. According to the town records and the tax maps, the frontage of the lot was 175 feet. It's a 2.2 acre lot. Many of the surrounding houses on Highland Street are similar or smaller sized lots with less frontage. I figured I would buy the house. It was a real in disarray, so I've been working on it for 4 months, fixing up the original house. And I was planning on coming in for a variance possibly to split it into 2 lots, which I was only gonna be 5 feet short of, or purchase 5 feet from one of the neighbors, so I could just do a simple subdivision and put another house to the left of the property. I got into a contract with the neighbor for the 5 feet. We made a deal, and he had agreed to sell me the 5 feet. So I had an engineering firm go out there and do the surveying, and after about a week's worth of surveys, they informed me that I actually only have 150 feet of frontage there. That the tax map is incorrect, and there's only 150 feet. So we did some deed research, hoping that maybe there was a sale in the past, and it wasn't recorded correctly type of thing, but we came up with nothing. So here I am today. Granting the variance would not be contrary to the public interest. The lots will still exceed the minimum standards of acreage, with the exception of the lot frontage. Allowing the lot approval would not alter the character of the neighborhood, because many of the existing homes have 75 feet or less than 75 feet of frontage, therefore it would not be contrary to the public interest. I put up a small map of the tax map up on the board. On that one page, there's 45 lots that have less than 75 feet or 75 feet of frontage that I'm asking for my lot. So their surrounding area is completely surrounded with lots that don't have the proper frontage. Granting the variance would not be contrary to the spirit of the ordinance. This is within the spirit of the ordinance because the lots will still be larger than most, exception to their frontage. Most lots on Highland Street have less frontage and acreage than the proposed lots. Granting the variance would not alter the character of the neighborhood because the lots will be similar in character and size to the surrounding properties. These proposed lots will not threaten public health, safety, or welfare. The sole purpose of this lot will be to construct a single-family home, ultimately matching the neighborhood's character. I put a small rendering of the house that I would propose to build that will fit on there with the setbacks.
The plan, you mean?
Yeah, the plan of the front of the house there,
Yep. Oh, the elevation.
something to that.
Oh, I
right
see
there.
it now. I'm sorry. I'm just being stupid.
Substantial justice would be done by granting the variance. Hereby, substantial justice will be done by granting the variance because the owner will get 2 lots that will be similar and conforming in size of the other surrounding lots. Granting this variance would not give the owner any more than the others in the neighborhood currently enjoy. As the public would gain nothing by strict enforcement of this ordinance, the public has nothing to lose by granting this variance because the lots will be similar in frontage and in most cases, larger in acreage. Additionally, the applicant is only seeking to build a single-family home on the same size lot and frontage as other surrounding properties. The value of the surrounding properties will not be diminished by granting this variance. In this case, granting the variance will not just diminish the surrounding property values because the lots will be substantially similar to other lots in the neighborhood. After the construction of a new single-family home and the extensive rehabilitation that has taken place at 76 Highland Street, the value that will be added to these will only improve the value of the surrounding properties and therefore will not have a negative effect on the surrounding properties. I also attached a letter from Cardinal Realty out of Nashua, backing up, the value of the home should be worth it $300,000 to $350,000. Little enforcement of the provisions of the ordinance would result in unnecessary hardship. The hardship of this lot is the narrow nature in the wetlands in the rear of the property. Normally on the lot size of 2.2 acres in this zone, one would be able to make several lots out of this one lot. However, because of the shape in the wetlands and the frontage issues, I am currently not able to do so. The proposed use is reasonable because I will construct a single-family residence which will be in character of the homes in the surrounding area. I did put up a small, the bottom one there is a subdivision that was done on Nellie Court. It was similar in size of the acreage which I have on 76 Highland, and they were able to put 7 homes were constructed in that area, 6 or 7, on the same square footage of acreage as which I currently own. It's just an example of, what you'd be able to do with such a size lot, and if I wasn't stuck with a couple of the hardships here. That's all I've got.
Okay, thank you. Anybody else wish to speak in favor of the applicant? Seeing no one, anybody wish to speak in opposition or neutrally? Again, seeing no one here, I declare it before the board to Discussion. Board,
Question, to the applicant,
go ahead.
where did you see something that said 175 feet of frontage? I know it's listed here a couple things, but I don't see it in the tax map, I don't see it. Oh, it's right there.
It's right there.
Up there, yeah, our GS had it, so it wasn't on any tax or anything like that, it was just in the GS only. It's not in writing anywhere, it wasn't part of the bill of sale or anything like that, or nothing like that.
Well, I was told by the owner that he also believed it was 175 feet.
Yeah.
I mean, it's kind of,
I guess the
I
question,
don't think he really know either that he didn't own the 175 feet.
did the deed have 175?
That's my question, because that should have it in there, should have the actual lot dimensions on a deed.
I don't think the deed said, after I did my research a little bit more intently, I don't think the deed had the 175. I think it said 150.
It did.
You bought the house with the deed, so it was in there somewhere when you signed the PNS.
Okay, thanks.
I just wanna make sure there's no confusion there, because either you have it, or you don't.
Yep.
And by the time you sign a house, that's all there. I know most people don't understand the whole process, but it's there somewhere. So what's actually you buying, so.
Well, sometimes it's not right, but he said
Sometimes
it
it's
was
not right.
150.
Yeah.
Okay. Other questions? Other, go ahead.
I go by this house 10 times a day, and know where he's proposing to build a second house. There's nothing but a hole in the ground. And to me, it would be an improvement, because it's not buildable right now, the way it is presently, so
It's depressed along that.
it is, it
Right.
certainly is. And keeping with all the other properties that don't have the adequate frontage, so we're just going along with the neighborhood, so I think it'd be a good use, personally. Yep.
I was gonna ask that question. Well, first of all, they're both acre lots in the end, even after subdividing, which to me is what a house should be built on, but what is that depression? Was it just all natural? Does it fill up with water? Is there a sewer there? Is
I think it's been there forever,
I know it's
right?
been there for a long
It was
time. I mean,
probably a swimming pool
No.
for the other lot, no?
Doesn't it go
No,
way
it's
back?
huge, it's big, it's not
It goes-
a
No, it's
man-made
all-
depression.
And it kind
per
of
se.
goes into the neighbor's property also. He has a similar depression,
Yeah,
then it
right.
goes up to his.
So how are you planning on addressing that? Are you gonna obviously put a full basement in this property and backfill everything in?
Yes.
Is that your goal?
I was actually gonna, if you look at if you're out at the property, the backyard actually goes up and then rolls back down. I was gonna re-excavate some of that and
Move it
take
around.
some of that dirt forward and,
Town sewer there?
town sewer and water.
That's what,
Yeah.
In water?
yeah, so you're not worried about the septic issues or anything like that, or?
So-
It is kind of a lake there when it rains.
Oh, it has to be.
It's
It
like a
has to
little
be.
pond.
Yeah.
Whereabouts? Where are you gonna build the house?
Yes.
Yeah, because of the depression's there and there's no
Oh, I
drainage,
see.
so-
I was gonna sit right in.
It's not the wetlands then?
No, the wetlands is in the far rear of,
Yeah.
Rear,
way,
yeah.
way down.
Tonic pond.
You can see the
You can see the swells right
topography,
there.
it goes down, must go down 100 feet.
Oh, maybe not 100.
No, I'm talking in the back.
Oh, yeah, yeah, yeah.
The
that-
very
that's-
back where the wetlands is.
Other questions?
No, just a comment that I was chuckling to myself because this is taking a lot and creating two non-conforming lots. But the intensity of it is very different than the previous case.
Agreed.
And it is in keeping with the character of the neighborhood, as long as it's a single-family house that stays there. That's all. That was just my comment. And I just love zoning for that reason, because everything is different on every single case.
Every case,
Every
absolutely.
case is totally
And
different.
that's why I have an odd number of people on the board, because we always don't disagree.
Right.
Beauty of it. Okay. Other,
You love zoning that much, huh?
I love the town more.
I know, me too.
okay. Anybody willing to make a motion?
I am.
Okay,
Oh, go ahead.
Go ahead.
You know, I'm gonna make a motion to grant with one stipulation, is to have just a single-family house developed on that
Same
lot.
thing.
Understood.
I'll second that motion.
Okay. No other stipulations?
The applicant okay with the stipulation before we vote? Isn't that normal?
Yes, my only intent is to do one single-family house there.
Correct.
Okay.
I agree.
Okay.
Poll the board?
Ms. Davis?
To grant with one stipulation for single-family development.
Mr. Dearborn?
Likewise.
To grant, I suppose.
Hey, Grant.
Mr. Petrie?
The grant with stipulation?
Mr. Hool is votes to grant with the stipulation, and Chairman Brackett.
To grant. 5-0, you're,
Perfect, thank you very much. Yes.
Hopefully that doesn't turn out to be a sinkhole and suck the house down.
I think it's compacted, it's pretty good, it holds water. So I'll have to, like I said, I'm probably gonna trench back and daylight, foundation drain,
Yeah, the
backside lower part.
building inspector will be talking about all that stuff.
Okay, thank you very much.
Thank you. Again, 30 days
Yes.
and appeal period, so if you do anything ahead of the 30 days, it's at your own risk.
Yep.
Okay.
Thank you.
Okay.
I'm saying the one stipulation that only one single-family home is to be constructed on the newly created lot,
Agreed.
because I don't know what the number will be.
A lot.
Yeah.
And you're keeping the, well, it's after the vote, it doesn't matter, but you're keeping the current home, you're renovating for another single family anyway.
TR
Do-
zone.
Correct. Oh, that's right, TR zone, no multi-units.
Okay. Can we take, is that, everybody agreeable to taking it out of order, to take up that appeal next? Is that the last thing, right?
Sure. Instead of the minutes, sure.
Yeah, I think we have a patient person that's been here through this whole meeting waiting,
Packet.
so if we can jump a little ahead. Would you read the? Case in? There's not much to read.
It's a request for rehearing, case 191-12, home occupation, approved with one stipulation, April 26, 2018, 14 Regina Street, Hudson, New Hampshire. And it was a application request for a rehearing.
Just so you know, an appeal is heard strictly through the board. There's no testimony, but we do have what she submitted to us as a basis for the appeal. Does everybody have that?
Yes.
Okay. Discussion?
I was the maker of that motion to grant it with one stipulation, and that being that the children under her care be kept inside, and she's come up with documentation saying they are required to be outside. My only question is that this documentation that requires outside activity, is it in a non-conforming zone like this particular case is? And I had asked the applicant at that point in time whether she was contemplating putting up a fence between the abutters property, and she said it was too expensive, but I see in her testimony now that she's got 3 people quoting on it. I went by the property and that fence is not erected yet, so I don't know what the outcome is right now.
Understood. I don't know either, and I would offer maybe she's waiting to hear what happens tonight.
I would think so.
Other comments?
No.
I guess I'd like to make one, go ahead.
I had voted no to
I
the
did
original case. And the reason why is because the applicant stated at that meeting that she couldn't meet the requirements of a home occupation special exception. Because, well, she was gonna keep the children inside, right? So the activity of the home occupation was going to be solely inside. And now we're hearing that she can't meet those requirements. That would negate the whole home occupation.
Oh, I took it to, when she submitted the information from the state saying they required outside activities, and I was in favor of the stipulation too, because I thought that home occupations, this kind of home daycare was done inside. And I was clearly wrong on that point. And I also was given a past case from Hudson where we talked about having fencing outside for outside activities in the past. So I was doubly wrong. So I hear what you're saying, so it's a different application, but I'm not sure it is different, other than the stipulation. And to me, we can do what we want to remove the stipulation if we choose to.
Yeah, but it's, I guess what I'm saying is.
Because
is
the
that-
application didn't come through with a stipulation from indoor activities. We superimposed that at the meeting that night.
But part of the home occupation special exception application states right on it that all of the activities of the home occupation shall be conducted inside the home.
I
So
understand,
regardless of whether we have a stipulation that says it's required or not, it doesn't meet the requirements. I think it probably needs a variance or something.
but I offered that
different.
I've offered that we've never asked for a variance on this, and that it's always been conducted partially outside, given the requirement of the state and the example of a past application. So I think historically, we've treated this as a typical home occupation, but the conditions of this type of home occupation is that it is done partially outside. So a variance in my mind, it's a little bit overkill, you know?
If I could address that?
Go ahead, please.
Shortly after I started here, there was an application at 14 Grand Ave for a daycare. The tables say that daycares are supposed to be done as a special exception. Had the applicant do it as a special exception, was told by this board that it's not a special exception, it's a home occupation.
That's
We
what
came back, we renoticed it as a home occupation, and it was granted as a home occupation for daycare. So I'm just saying that the past history of this board was treating it as a home occupation.
And we have for 30 years, that
Right.
I know.
Right. And I agree with you. But I think what I'm saying is that we've never really addressed all of the elements of a home occupation on that application. The applicant themselves say that they'll comply with it, and then it's approved or not approved. Maybe we need something different from a home occupation that's gonna have activity that's on the outside.
I think we need to.
And we've never had a butter testimony, to my knowledge, that was so adamant about
Well-
the activity outside.
I think we need to correct the discrepancy in our regulations. Fix it for this.
Well,
And it's not it's not the only thing we've gotta fix, so this thing's been around a long time.
I think just for daycares. We all know there's numerous daycares in this town, sanctioned, not sanctioned, legit, whatever you wanna word it, and they all have outdoor stuff. Kids
Well,
can be
even
outdoor,
just-
fenced in, so.
Yeah.
And other business, home occupations are the office for taxes, or the office for a garage, you don't want them doing garage work in their yard, all that kind of stuff too. This is
Right.
the only home occupation that I at least envision having that type of extra criteria. or
We've
stipulation.
actually, I was looking back, we've actually talked about fencing in the
Absolutely, in
past.
some cases. And some applicants, they said they had, or just came out, oh, your kid's outside at certain times, okay, whatever. No butter testimony, like you said, so it's been both ways.
The other part, my thinking on the abutters testimony, let's say I was upset that one of the abutters said that his dogs run in the backyard, so these kids shouldn't be let out there, they might get bitten by a neighbor's dog. I think, I wouldn't wanna see that happen. I think that's be atrocious. But I think it's the neighbor's responsibility to maintain safety for his animals in the back, in the neighborhood. In a way, it's the cart before the horse. This person isn't responsible for what happens with the neighbor's animals. Although, if it happens on her property, I'd feel very bad. But it's the neighbor that needs to make sure that their animals are kept away, I guess. Maybe the fence will help that, I don't know, but that was one of the, as far as I could see, there was two neighbors that testified, and this was one of them.
Right.
But go ahead, that's what I thought.
There was, on her explanation, there's two questions I have that I would like to ask the applicant. Number one, she states that there was a letter supporting her daycare, I don't remember that acknowledging support for a daycare from the abutters, do you?
No,
You have the notes in there?
She states in her request here that
we'll
that
check.
there was a letter submitted, and also, what was the, I forgot the other one, about the fence, she said that fence was too costly, and yet now this one states that she's gotten 3 quotes on the fences, so
Oh, I think,
that would appease the neighbors.
I think fencing, having looked at the past one and recollection of us, fencing is an issue for us.
Mm-hmm.
And I think we can address that here if we choose to. Go ahead.
Mr. Buttrick, this came in on the 4th, correct, as I'm seeing it? So,
May 4th.
you're gonna, discussing to rehear this case. Now, if anybody's familiar with Belanger v. Nashua, you could do a motion for reconsideration, because it's within the 30 days, and reconsider and remove the stipulation, and you don't have to have the applicant come back for an appeal. It makes the process a lot easier for the applicant. Just throwing that out there.
No, I think that's,
But that, to me, in my mind,
Go ahead.
doesn't solve the issue, because if you look at the
I
conditions of the home occupation special exceptions, one of the conditions is the activities inside the home. So that's not gonna solve it. I think what you need to
I
do is
understand.
you need to, if the board so choose, is that you need to accept the appeal for a rehearing, right? And then rehear it and put a stipulation on that says the activity can be outside. So reverse it, that's what needs to get done.
it's the
And
other way
maybe
of doing it.
fencing and other things, but
I
that's,
I
we need to,
I
we
think
need
it's unfortunate that that it's taken so long to get maybe through this process, but go ahead.
I just add, I don't think the board should hold the, home occupation wording, against the applicant.
No,
Well, no, I just wanna say this, it's not that you're holding it in a bad way, but, make it the issue of this application that it doesn't meet the criteria for a home occupation special exception.
it doesn't matter.
With
The applicant testified at the hearing that she was operating the daycare anyway, so it doesn't matter. She's not being held back on anything, so she's operating it without a special exception.
I do understand. I find it unfortunate that we've had this for a long time, we haven't caught it. But I also find it unfortunate, we have several issues and conflicts in our regs that it hasn't been cleared up in 2 years of meetings.
Correct.
So I understand what you're saying, but I understand Ms. Davis saying that she wants to
I
go
do.
correctly through the procedures, and I don't have a problem with that.
I
But
agree.
And I say it publicly because we put ourselves through needless worry and consternation because of what we have in our regs. So, anyway, I do recognize that the applicant was having kids in there now, and but interested in hearing a motion.
I'll make a motion to rehear.
Anybody second it? No seconds?
I read the minutes, but I didn't sit in the case, so
No, I understand.
I didn't wanna jump on that one.
I guess the motion dies.
Nice, yeah.
Well, the thing is that I voted to deny it first time around. So I don't think that I'm in a position to rehear it. I mean, we can rehear it, I don't know whether that testimony would ever change my opinion.
Okay. Any other motions?
I believe, Mr. Hool, you denied it too, right?
Correct,
Correct.
yes. So we're
Are we,
in a quandary here.
so the motion is to, the motion, I'm just trying to work it in my mind of what am I gonna hear differently that would cause me to change my decision? I mean, that's the purpose of the rehearing. What's the new testimony that I'm
I
gonna see?
understand,
That I'm gonna hear, that's all.
um, don't have an answer.
Oh, in her request for rehearing, she did say she'd put up a fence, obviously, that was a concern, but it's irrelevant if the activities are limited to the inside. And I think that's what you're struggling with.
Well, I think what we're doing is that, I mean, how can I say this? I think what the problem is that the home occupation special exception states that the activity of that occupation needs to be within the home. The applicant has testified or has stated through this rehearing request that that can't happen. So she needs a rehearing to remove the stipulation and to put a stipulation on to remove it from one of the requirements of the home occupation itself. So that's what we need to do. That's what the request is. And there's also, we need
Long-term to address that. part.
long-term, yeah, to address, it. But no, I'm just thinking
no,
about this
we're not here
particular
for long-term.
applicant.
No, we're not
Just
here-
this
this is not-
particular applicant
Correct.
needs to come back to us with new testimony of why, that's gonna change people's decision on,
I understand.
okay.
The problem is that one of the people that sat on the board isn't here.
Mm-hmm.
And the other is that the fact that it's inside, outside might not have any bearing on the decisions made by some of the people. Go ahead.
Question for Mr. Buttrick. When was the zoning ordinance, this home occupation special exception zoning in the zoning ordinance adopted?
Why?
Well,
I've been on the board since the early nineties and it's been the same.
Pretty much.
the same.
Been
With,
amended.
yeah,
We've
yeah,
When
but
was it
it's,
amended?
We
but
did some
the
parking
guts
stuff.
of it have been the same.
Yeah, we did some
Okay.
parking stuff and hours added to it and stuff like
Right.
hours of operations and stuff, but
Inspections after 6 months,
Yeah.
then after a year.
So,
But
I
it's
will
been
offer
there.
this. The board in 1998, the zoning board of adjustment, gave a home occupation special exception, which you see in the handouts that the applicant gave to you, for the same such thing, home occupation special exception for a daycare. It was approved 5-0, under the same criteria. I understand your concern, and I really hear you. I don't think that this is a case to set a precedent on. I think what we need to do is go forward and change the ordinance.
absolutely.
I agree. The issue, though, is the people sitting on the board today, it wasn't a unanimous vote. So therefore, we haven't got a second, and the people that aren't still unsure of the home occupation, irrespective of the outside.
Because we don't have a second to my motion, does this mean that this person continues as is with that
Yeah, so far.
They're not supposed to.
stipulation?
We have to decide
With
something.
that stipulation in place?
We have to hear this appeal and vote on the appeal.
That's right.
Can I,
Go ahead.
can I ask you to look up this property and on the, it'd be under Patriots property. I wanna know when the house was sold.
Which
Does anybody
address?
have that?
At
I don't think-
14?
Yeah, 14 Regina. I'm just thinking aloud, Mr. Chairman, if I may.
Please do. I think that's in keeping with the appeal process. Continue thinking out loud.
It's showing 12/5/2015, the most recent sale. December 5th, 2015.
2015, and, okay, yeah. So, is that to the applicant? I can't see that far.
Yeah, Jennifer
uh,
LeBrun.
Okay, and then, before that, I'm trying to find,
13 from Jason LeBrun.
so,
That was
when
a
did
thing.
Karen Hudgens own it? Is that who?
I don't have that.
It was in between,
Oh, that-
it was in
that-
between
I think
92 and
another case, I
2005. They had Home Mortgage Corp., that's probably the owner of the property at the time. So she might have been renting. Because if you look between 92 and 2005.
Well, what am I looking at here then?
You're looking at another property.
Oh, these are just examples
at
of
12
other?
Exactly.
Oh, I thought,
Yeah, yeah,
sorry,
no.
sorry, I thought that there was a home occupation against this property
prior?
at one point prior, so that all of the,
Whole different
Well,
property approval.
okay, sorry. Because that would have made a difference if that,
My sense is that we should stick to the narrow focus of the appeal and then rehear it, given the difference of opinion on the board. Remember, if we rehear it, we have the right to hear everything again, as if it never happened. But all we're doing is asking about putting it inside or outside now, so that we can rehear it in a different context. Doesn't mean you agree with anything other than the right to rehear it at her request. And I believe new testimony has come and more information has come. One, that the state requires outside, where I know I said I didn't think it did before, so that was an error on my part. Change in what we voted on. And the other is that we have voted in the town for outside,
For daycares.
and that's also an error. So if we take the strict context of the appeal, and without any of the background noise, I think we have new evidence, without opinion, that we should rehear it, period. I don't think we're saying that if you make a motion or vote to rehear, that you agree or disagree with the outcome of the next discussion. And it doesn't fault you for anything you voted in the past. It's just recognizing the state requires it, and the town has done this for a long time. So we have made an error of judgment on the strict part of it. Does that help anyone?
Supports my
The
motion.
state,
can vote on
the
that.
state knowledge has changed some of that
Well,
stuff.
I'm
And
just
I think
saying-
we knew it was there before, because it had come up before, a long time ago, when we first started hearing some of these in-home daycares, and some of the applicants were coming in with the state requirements, specifically on how many people could be there, how many kids per ratio, and all that. So that has come up before.
There's never been a real point of discussion about inside, outside.
Well, some
Other than
applicants have brought it up, because of the requirements from the state, and that's been there for quite a while, I think, some of those. But it was never in our RSAs or our zone and
So-
stuff, so
I would say in that strict context, she has the right to rehear it.
we would concur.
Anybody make a motion on that thinking?
I did, I made the motion to
Motion,
rehear.
anybody second the motion?
Nobody did.
Judging from what I read in the minutes and what I'm listening to, and.
You'll second it?
I will second it.
Okay, we have a motion and a second. Would you like to speak on your motion?
Only because I think there's more testimony to come on the rehearing regarding the fence, regarding the abutters positive letter that I don't remember hearing from.
Okay.
Maybe there was other facts. The only question I have is that this clarification from the state as program requirements, this doesn't say that it's in a non-conforming zone. That's,
I don't
This
think
is-
it's,
this
it's
is-
a
this is
general
re-
requirement. I
yeah,
understand.
and now we're stepping one step beyond a little bit on this Regina being in a non-conforming zone.
Remember, that's for the rehearing,
Yes,
okay? You hold that thought. and
I
we'll-
certainly will.
The second?
My opinion on rehearing is usually based on some new testimony information that would make us look at it again, and that was provided tonight with some information from the state of New Hampshire.
I'd just like to clarify that there's no nonconformance. In the TR zone, home occupations by special exception, family daycare homes by special
Oh,
exception.
I'm sorry, okay.
Okay.
Oh, that clarifies that.
But all that's for, again, in my mind, I know I made an error in judgment on that fact that it's gotta be outside, so that's her specific request for appeal. Hold the board?
Okay, Mr. Dearborn,
To grant a rehearing.
Mr. Petrie,
To grant rehearing.
Ms. Davis.
Not to rehear.
And Mr. Hool votes the same, not to rehear. And Mr. Brackett,
I vote to rehear. So it's 3-2. You get to rehear, re-present your case. And I would offer to take everything, confused as it may be, from the board to present your case with. Thank you.
Right, can I just add for clarity, it needs to come in as a new application, like you were presenting
new,
for the very
yeah.
first
Oh,
time.
no.
Just so you know, we will disregard everything
Everything we
said.
heard
Yeah,
before.
It's gotta be renoticed,
Yeah,
everything.
and-
It's
yeah,
a
yeah.
complete application packet with the fees. It is,
With the fees?
yeah, it's a new hearing.
And remember, there was negative abutter testimony,
There has to be fees.
so
Other
you
fees.
should really
It's a whole new,
Negative
be able
tax.
I think
to
the fees
be
are
prepared
appropriate.
to
Even
address
because
it.
we failed
Yeah.
to,
Yeah, okay.
But if it was an error in judgment on the board, I think the fees are.
I question that.
We still could have put the restriction on it,
1 second.
you know. Okay, thank
Are we
you.
gonna rehear it at the next meeting? Is that what?
I'm not sure this
Um,
person know that or not.
we've got space on the agenda at the
Let's-
moment. The
hey.
deadline for June would be like the 6th or 8th of June,
Can you notice in time? Yeah, you can notice.
That,
in time.
yeah.
Is that
8th of June is only for,
Toll Street?
That's a
Toll
different,
Street.
no,
No, no, no,
he's
it's
for,
the application deadline for getting
Oh, Friday
applications in.
deadline.
Oh,
Right.
oh, oh.
The
It's a
10th.
Tuesday, it's like the
10th,
second
yeah.
Tuesday or whatever.
okay.
You should probably, we'll put this first.
Oh, I can tell you right, exactly.
We
We'll
can
put
do
this
this
first.
first, yeah.
We
Let's
put
do
this
this
first.
first on the next regular meeting.
Can, yeah.
All right. You ready for the next regular meeting?
June 12th.
Thank you.
The application is June 12th.
Okay. Next would be the minutes of the meeting. Comments?
There's actually, should be two. I had two prepared for tonight. You got the April 26, 18 minutes and May 10th, 2018 minutes as edited.
Yes, you may. Hey, don't be touching my shit.
April 26th,
Yep. Any comments on the April 26th?
comment on page 2.
Go ahead.
First, line 3 on page 2. Should that, I just have a question. Should that be, at the end of that sentence, our existing non-conforming lot of record? Or is that, am I not reading that correctly?
Both the lot and the building
I
are
think both.
existing non-conforming of record. It's at the beginning of the sentence.
It's noting that both the lot and the building are existing non-conforming of record.
That's why I asked. Thank
That's
you.
fine.
Still on page 2. Any more? Page 3. Next page. Any comments coming up? No more comments on the April 26th,
Nope, I think,
24th, 6th
oh.
meeting? What?
she got all my comments.
May 10th meeting, comments? None? Any comments?
I have a comment. These are the best minutes I've seen in my 7 years on the board. These are excellent. Yeah.
Blowing.
I agree, they're the best I've ever seen, and the next one was Ann's minutes, they were,
Ann
It's
Seabury?
great.
Yeah.
Mr. Seabury was
That
here.
predates
God rest his
me.
lovely soul. He might have to say something different.
Although it did take us a while to get accustomed to editing them.
Yeah,
I think
working out
Ann's
good.
and Brad's minutes were so complete, there was a request to shorten them. So I take that to heart too, so, thank you very much. Oh, that one?
She had a question on her own
Oh,
minutes.
you couldn't have it.
Oh, yeah.
Stated that there is ambient noise to take into consideration and noted that the noise appears to be louder at night, and noted sound seems to be louder at night. You gotta pick either or.
You could say sound appears to be
Okay.
louder at night. The idea is the background noise isn't as loud, and that's what I was saying. It's more noticeable.
Thank you.
You and I had difference of words on that one, I think, was it?
But it had the same idea.
Oh, we had the same
You
issue?
said sound appears, I said sound seems,
Yeah, which
because
is-
sound
which is true.
technically doesn't appear.
So, attitude on
It's the second definition of the word appear.
Oh, I get it now. Thank you for the clarification.
Okay.
motions on these, do we yet?
Oh, I'm sorry, motion to accept April 26th and May 10th. All in favor, say aye.
Aye.
Aye. 5-0 both, so. Any other matters before the board?
You were May 10th?
I did them both at once.
Oh, you did both at once, sorry. I didn't hear it.
Anything else? Any other motions? Guess we'll stay here until we get a motion.
Since Mr. Martin can't make a motion to adjourn, I will.
It always comes from that side of the room.
Let's see, we can hold them up and see what happens. huh? Okay. Okay, procedural, all in favor of adjournment?
Aye.
Aye.
Thanks.
Everybody have a good Memorial Day weekend.
Thank you.
See you at the parade.
Sure.